Hi, and I'm going to talk to you about a very recent legal case in Canada, Ewert versus Canada Correctional Services. The federal court released a decision on September 18, 2015 in Ewert versus Canada Correctional Services allowing an action against Correctional Services Canada for an unjustified violation of the plaintiff's Section 7 right to life, liberty, and security of the person under the Canadian Charter of Rights and Freedoms. Jeffrey Ewert is a 53-year-old Métis prisoner and claimed that the psychological risk assessment tools used by the Correctional Services Canada weren't culturally appropriate for Aboriginal prisoners. Ewert also argued that these tests had an adverse impact on him. Ewert brought this claim against the Commissioner of Correctional Services Canada for damages based under Section 7 of the Charter. Ewert brought this claim on his own behalf and on behalf of all Aboriginal prisoners in Canada. There are 5 psychological assessment tests at issue in this case. These tests are ostensibly designed to assess the risk of violent and sexual recidivism, the tendency to relapse into certain mode of behavior, as well as psychopathy among prisoners. The tests are applied to Aboriginal and non-Aboriginal inmates alike. The specific assessment tool I wish to discuss today is the PCLR, or the Psychopathy Checklist Revised. This checklist was devised by Dr. Robert Hare of UBC and was compiled using a sample of Caucasian men. It is based on 20 questions, each being able to get a score of 0 to 2 for the most possible amount of points accumulated being 40. While psychopathy is vastly considered to be on a continuum, there is a cutoff point of 30 in which the subject is labeled clinically as a psychopath. As well, there can be an inter-rater bias which can affect the score, and thus one rate might give the defendant a 27 and thus not a psychopath, while another rater will give the same defendant a 31 and subsequently labeling them as a psychopath. There has been little tests and studies done to check the cultural reliability and validity of this test. However, the tests that have been done critique the findings, especially in the Factor 1 of 2. In Factor 1, personality characteristics such as glibness and superficial charm are assessed. They have said that this factor is unreliable amongst the Aboriginal population. Dr. Hare created the checklist for the sole purpose of it being used for research. He had never intended it for it to be used in the legal system or as a defining tool in determining the likelihood of recidivism of a defendant. The court found that the results of the tests are significant to the experience of prisoners in the penal system. The results contribute to the individual security ratings of inmates. The results can also influence whether inmates will be allowed escorted temporary absences from the prison. Finally, the test scores can be included in the assessment for parole. The defendant, Jeffrey Ewert, scored in the 98th percentile for Factor 1 and only in the 51st percentile of Factor 2, which is considered to be within a normal range. If in fact there are cultural biases which inflate the Factor 1 scores, then Ewert's psychopathy score would more than likely not exceed the arbitrary cutoff of 30. The court found that Ewert's scores were used in a report prepared for his parole that labeled him an undue risk to society. Ewert alleged that the results of the test would render him unlikely to be granted parole in future hearings. For this reason, Ewert consistently opted out of parole hearings. Dr. Stephen Hart was called upon to act as the expert witness for the plaintiff Jeffrey Ewert. Hart provided evidence that the assessment tests are susceptible to various forms of cultural bias. Hart argued that he would not use the scores of the assessment tests of Aboriginal inmates because of the cultural differences between Aboriginal and non-Aboriginal groups in Canada. Overall, the court found Hart's evidence to be persuasive. The court noted, in particular, Hart's objectivity and balanced approach to the issues, while the defendant of the Correctional Services Canada expert witness, Dr. Rice, supported her argument by citing a study that used very few Aboriginal participants and failed to include her role in the research as one of the lead researchers. The court relied heavily on the evidence presented by Dr. Hart. The evidence presented by the defendant's expert witness, Dr. Rice, was generally disregarded. Based on the weight of the evidence, the court determined that Ewert was successful in proving that the assessment tests were unreliable due to their susceptibility of cultural biases. The court also found that the results of the tests negatively impacted Ewert by increasing his security classification and reducing his desire to apply for parole. Ewert was deprived of his liberty because the test results made parole practically unattainable. Ewert's security of the person was also infringed because he was labeled as a risk to society and psychopathic based on his test results. All of these accounts infringe on Section 7 of the Charter of Rights and Freedoms. The court found that the assessment tests went beyond their intended objective of identifying inmates who were threats to public security. And by objective, this should be clarified as the legal system's intended use for it and not the developer's intended use for it when it was created. The court declared its intentions to issue a final order preventing Correctional Services Canada from using the test on Aboriginal inmates until studies could be conducted on the reliability and the remedies hearing order to address the best and fairest manner of the implementing this final order. Further, the court ordered that Correctional Services Canada cease using the results of ewert's assessment tests. While this recent case is by no means a means to an end, it does reflect a current change in the Canadian legal system and how it is not appropriate to use the same tools of assessment on every individual. I am excited to see how this story develops and if it is the beginning of a snowball of change that we can see in the Canadian legal system.